Your Honor, I'd like to offer Mr. Minkle to testify, please.
In this proceeding, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
See.
Mr. Minkle, your age is 45.
Yes.
Have you paid strict attention to the commentary by your sister during the course of this trial?
Yes.
I think at least once she said Charlie was Mom's favorite. Sir, how many times did you hear your...
Objection, Your Honor. Just before we get going too much longer, counsel is leading the witness. I believe this is his witness, and I would object to him leading his witness.
I'm not sure that it's a leading question.
Overruled.
Mr. Minkle, how many times did you hear your sister in your 45 years make that statement that you were Mom's favorite?
How many times?
Yes. Could you count those times?
No, I can't. I couldn't possibly, or, it was... No, I can't. I couldn't possibly count how many times I heard her say it, but it was frequently, yeah.
And when she made those statements, sir, what did you suspect?
I don't know. Doesn't have... it was just a thing, Mom likes you best, and it was just... I never took offense to it.
You didn't take offense?
No.
All right, sir. You've helped at home with whatever chores were necessary on the farm.
Yes.
That included seeing that the farm was leased to people who in fact farmed it.
Yep, every year to carry
And,
leases.
Sir, why did you choose to lease to your neighbor farmers rather than farm the farm yourself?
Well, when Dad died and the equipment, in order to... he hadn't farmed in a long time either. And to buy the equipment and get the farm back in shape and do all those things it was just cost prohibitive. I had a job in town and so I couldn't farm the farm and work in there too.
Did the leasing of the farm then bring in some income for the farm?
It sure did, you bet.
And you had employment, sir, over the years?
Oh yeah, I had... Well, after I got out of the service, I just kind of bounced from job to job, and I had summer jobs that, in the fall, that was all done, and so on. And the last job I had, of course, I was custodian at Mueller's, and I went in on Friday, and they said I was all done on Monday. And I don't know. You go on to talk about despondent, yeah, but I don't think I was the only one in Port Huron that was despondent over that.
You were despondent over losing the job at Mueller Brass?
Yeah, because I
mean?
thought, well, there's a lot of guys that lost their jobs there that was despondent. I thought I was set for the rest of my life there, So.
All right, sir. What did you do with your wages over the years, please?
Well, I bought a car.
All right.
I have a nice bank account, not $1 million, but I helped Ma out at the farm. We needed something when I paid for the roof when the roof needed to be repaired on the house. We ripped her off and I got the shingles, and neighbor and I put the roof on, and I paid for that. There's things around there that I paid for, sure.
Okay. You never kept any accounting over the years?
No.
Never.
She'd cash her Social Security check and I'd go get the groceries. And
You grocery shop for your mother?
oh yeah, she never...
Okay.
It wasn't that she wouldn't get out, but it was. I would be on the way home, and she'd give me the list, and then I'd just pick the groceries up for her.
All right, sir. Did you have a discussion with your mother about leaving her estate farm to you? You have to answer, sir.
Well, no, I never come out and just said, Ma, I want you to leave everything to me. No, I never said anything like that. We never had a discussion like that. She told me she wanted to draw up a will and And so I said, I thought it would be a good idea. I really did.
Did you ever say to your mother that you thought your sister should be excluded?
No, I never said she should
Did
be
you ever
excluded.
say anything to your mother about anything concerning your sister and any inheritance?
No, I never said anything about the inheritance. I said, she must make couple $100,000, but I never saw her income tax statement, but I just assumed her being a doctor and all, that and she had those 3 clinics. I didn't think $200,000 a year.
She had 3
was
clinics?
Too much. Huh?
3 clinics?
I think she had 3 clinics now, 2
I
or 3.
see.
Yeah.
Sir, where did you come up with the number 200,000 if you came up with it anywhere? Just out of your own mind.
Okay.
Is that your experience with...
Well, you're talking about a plumber, you say, well, he makes $300,000 a year, or a judge or an attorney, you just have a figure in your head, because they're well paid.
Okay.
And I
So-
thought a doctor, I didn't think 200,000 was
Okay.
out of line.
Were you telling your mother that to lie to her?
No, we were just talking about it, and I said, well, she must make 200,000 a year. I know other doctors, and that's, I'm sure they make that much at least.
Do you know where the doctors live in this community?
Up
on the
Lake
lake.
Shore? Yeah,
Okay.
yeah, a couple of them, I suppose. The ones up in Yale, though, they just live there right on Yale Road. They don't. Nice places, though.
Okay, sir. Mr. Minkle, did you discharge a shotgun in your room?
Yeah, it went off.
Tell the jury what happened with how it went off.
Well, I went up there, and Sally, that
Who's-
Irish setter.
Oh, your
she come
dog.
up, no, I let her up. I should have never done that. I never let her in there, because we got those birds, and I had them in the back of that jacket. And I'd taken them out downstairs, but she still could smell them. We got up there in the bedroom, and she was going to, put her nose in the back of that jacket, and she jumped up on me, and when she did, I slammed the shotgun, butt went on the floor, and
The
I
gun.
put a hole not only in the ceiling, but it went right out through the shingles. And it just discharged. And I said it was an accident, but I think Ma, because I've been down in the dumps so bad losing that job at Mueller's, that she said, well, he was cleaning it, but
You weren't cleaning it.
no, I know how to clean a weapon, and it didn't go off cleaning.
Did you explain to your cousin, was it Frank, how that gun went off? Did he ever ask you how it went off? Yes.
I didn't talk about I didn't really talk about it because I was kind of embarrassed, you know what I mean? You
All right.
don't go around saying, yeah, I blew a hole in the ceiling with my shotgun.
All right, sir.
You don't talk about that.
For the first time ever, your sister testified about a $2 million offer on the farm. Is that the first time you've ever heard that? Today?
No.
Had you heard it before?
Yeah?
Tell me about that.
Well, the line's drawn right down Yale Road, and there's not only that fellow she talked to, but there's 4 other guys, and they'd had offers on their farms up there. Something big come to town, but I'm living on our farm's on the wrong side of the road.
You mean all of your neighbors on the
North side,
on the north side?
Well, not all of them, but there was 4 of them there.
4 of them?
Yeah, they all got offers,
Big offers.
big offers. Yeah.
Was
Big.
there ever an offer made on your mother's farm that you know about?
No, I would know because I got the property leased, and if it was that kind of a deal, I'm sure, she would have said, come see me. No,
Nobody ever
Nobody
came?
no, I talked to the neighbors. Nobody on our side of the road got an offer.
You graduated from high school? Yes, sir.
Yes, I did. I graduated.
And did your mother offer to send you on to university?
Well, I went in seminary. That was, I suppose if I had wanted to, I suppose they would have sent me to school.
And why did you leave the seminary? You didn't complete it.
No.
Why?
Sure didn't. It really, after I got in there, it wasn't really what I thought it was, you know.
All right. So you voluntarily left.
Yes. Well, it was kind of a mutual
Understanding.
understanding between
All
the
right.
both of us.
And
I wasn't really doing it all that well there, and, you know.
you went into the military after that?
Yeah,
How long were you in the military?
4 years.
And I've already seen that little tab on your tie. That's 1st Division United States Marine Corps, isn't it?
Yep,
Serving Korea.
yep.
5th Marine Regiment.
First Marine.
First Marine.
1st Marine Division. 11th Marines.
And 11th Marines.
Yep,
You were in artillery.
Yep, you're right.
And were you honorably discharged from the Marine Corps?
Oh, yeah.
And since getting out of the Marine Corps, you've been home ever since?
Yep. Came home and worked on, you know, around the farm. Then I got just jobs off and on, you know,
All right,
bouncing
sir.
kind of back and forth.
Your witness.
Good evening, Mr. Michael. Would you please state the address that you live at?
12921 Yale Road.
And how are you related to the decedent?
She was my mother.
Okay. I just wanted to clear that for the record since your counsel had failed to question you with regards to that. Your attorney questioned you for some length of time with regards to your sister and various other things. I want to talk to you also a little bit about the relationship that you had with your mother. Did you have a good relationship with your mother?
Yep.
She loved you?
Yeah, I think she did. I loved her, I know.
And we've heard the previous testimony in this courtroom with regards to the extent of how much that you cared for the farmhouse and leased the farm out and helped your mother in many ways.
Yeah.
And in what other ways did you help your mother? Did you pay the bills, buy the groceries, take her to the doctor, those sorts of things?
Yep.
So that you did all those things for your mother?
Yes, I did.
Okay. You also stated that you have a nice bank account, not $1 million. But of course, if everything goes right in this trial, it soon will be $1 million, won't it? If that offer comes through from the big conglomerate ready to buy your farm.
That offer is never going to come. It's only on the north side of the road. I've talked to the neighbors, and we're not going to get a penny there.
Mr. Minkle, have you been to the Birchwood Mall?
Yeah, I've been to Birchwood Mall.
Have you seen what happened on the other side of the road from the Birchwood Mall?
Yeah,
Do you know how much those parcels sold for?
a whole bundle.
A whole bundle across the road from the mall.
But I've also been to Greenwood, and I've seen what's on the other side of the road from the Edison plant, and it's weeds.
Is Greenwood operating at this time?
Huh?
Is Greenwood operating at this time?
Oh, I don't know, but it's the Edison.
in
So it makes a lot
mothballs,
of difference
isn't it?
who's buying the property. You know, if it's a big mall coming into Yale, I think I'm home free. But if it's the Detroit Edison or the gas company,
What's my
I don't
understanding
think I'm going to
that
be able to sell it.
that from the correspondence that was discussed here at trial, that it is a mall developer.
Oh, okay.
At Yale.
Could be.
You also stated that when you left the seminary, it was a matter of mutual understanding. Is that correct? Isn't it true, in fact?
Yes, that's fair to say. that.
Isn't it true, in fact, that indeed the reason you left the seminary was because you were caught cheating on your final exams?
Oh, I left long before the final exam.
Well, if it was because you were cheating on exams. Maybe they weren't your final exams. Isn't that true?
I could have been cheating, sure.
Did you ever tell your mother that you had personal knowledge that your sister earned $200,000 a year?
Nope. Never told her that.
Did you tell her that she earned $200,000 a year?
I said, Mary probably earns $200,000 a year. You know how you just say things like that.
Why
That's
would you
not
tell your mother that?
Because I believe that she made at least that, probably a damn sight more.
But
Yeah.
for what reason could you possibly have had to tell your mother that your sister made $200,000 when you had no idea?
It was just conversation. You're talking about things. You make statements like that.
Couldn't it have
Yeah.
been that you were trying to influence your mother? Couldn't it have been just a little bit that you were put off, that you hadn't gotten the education your sister had gotten? That you yourself were so upset about your sister, you were trying to influence your mother against your sister. Isn't that true?
That's not true. I never ever put Mary in a bad light, I don't think.
Your good counsel also questioned you with regards to your record with the Marine Corps.
I had an honorable discharge. That's about, I come out a buck sergeant. That's
Okay.
not all bad.
So that you pride yourself on having been a good Marine.
Yes, I do. And defending my country like sure, you bet.
And at the time you were in Korea, was there a conflict going on?
You mean, were they shooting at us when we were shooting at them?
That's correct.
Yeah, you could say that.
Okay, and at that time, did you carry a sidearm or a rifle?
I carried a BAR.
Okay, and anytime you came into base camp, what was standing order coming into base camp?
To unload your weapon.
That's right. And wouldn't you also do that at any time you would go into your own home? Isn't a base camp like a home?
Yeah, I suppose you could say that.
So in effect,
But then on the other hand, we had guys, shoot holes through tents over there too, and that weapon wasn't supposed to be loaded. So it can happen.
but you were a good Marine. You came out a sergeant.
You bet.
You don't become a sergeant in the Marine Corps in 4 years unless you're pretty darn good. Isn't that correct?
You have to be pretty fair, yeah.
Was there ever any time you came into base camp and didn't unload your weapon?
No, that's
Clear
true.
your weapon.
Nope, I cleared her every time.
And what about coming into your own home after you'd been out hunting?
I know this sounds dumb. I really thought I had unloaded it out by the car. But when we got out, and then the dog's going crazy around those pheasants and everything, and the next thing it just slipped my mind. And when I took it upstairs, I couldn't remember. I didn't remember that I hadn't unloaded it. I would have put it right in the closet like that and just left her there till I went to clean it, I suppose, with the shell still in it.
You never bring the gun into the house?
No, I know.
Breech broken?
No, I admit that was a stupid thing to do.
A very convenient, stupid thing to do, I might add. Wasn't this just another method of attempting to influence your mother, sir?
Your Honor,
No,
excuse me,
she didn't know the weapon was loaded. I don't think. I didn't know. I never.
Wait.
I'd rather not,
Objection made.
I'd rather not have the lawyer testify to the jury on what he suspects. The case may be concerning the gun. He's to ask questions, Judge.
Mr. Nelson, you may ask questions, and this is cross-examination.
Your Honor, I believe that the court rule has recently changed with regards to the addressing of adverse witnesses in the fact that I don't have to inform the court that I'm treating the witness as an adverse witness, and I'm thus allowed to lead
Well,
questions.
he's not an adverse.
He's not declared adverse, Judge, and he's done nothing to be
The,
declared adverse.
He's the opposing party. If he's not an adverse witness, I don't know who is, and this court rule was designed primarily to do away with this formality, Your Honor.
I'll allow you to continue your question.
Thank you, Your Honor. Have you ever in the past tried to commit suicide?
Oh, yeah, when I was a kid, young, in school, about the 11th grade.
What was the reason for your attempted suicide?
I wasn't doing too good in school, and I had a bad experience with a young lady. And between those two things, that just about did me in.
It appears then that from time to time, when things don't go just your way, you become a little despondent. Is that correct?
Yeah. But I don't think anything any more despondent necessarily than other people get. You get down the dumps. you get down the dumps after Christmas, you know, and I admit to that. But I've never gone to a psychiatrist or ever taken medication for it, so I don't figure I'm really that bad off.
Earlier in your deposition, you had testified that you lived on the farm your whole life and took care of your mother while Betty ran away to Colorado. Is that correct?
I didn't say she ran away to Colorado.
Well, I can quote you from your deposition. While Betty ran away to Colorado,
Yeah? Well, maybe I said that to him, she ran away to Colorado. She did go after that guy out there, so you might say she ran away.
was she running from something at the farm?
No, I think she was running to something.
Okay.
Yeah.
I have no further questions, Your Honor.
Mr. Flanagan?
Mr. Michael, you can step down, please. Your Honor, we have no further proofs.
I have no further purpose, Your Honor.
Counsel at this time are about to make final arguments to the jury. Counsel for the contestant, Mr. Nelson, will have the first opening argument. Counsel for the proponent will then have his opportunity for argument. Then, in conclusion, counsel for the proponent will have an opportunity to reply to the argument of the counsel. Attorneys in making these arguments to you will be commenting upon the testimony that you have heard and the evidence that has been presented in this case. They will be recalling the evidence that has been presented. They will not intentionally try to mislead you. However, if their recollection of the evidence differs from what your recollection is, you must follow your own recollection. These final arguments are not to be construed by you as evidence in this case or instructions on the law. They are, however, intended to help you better understand the contentions of each side and the issues you are to decide. You should give both sides your close attention. Mr. Nelson.
Thank you, Your Honor. Ladies and gentlemen of the jury, during the course of this trial, you have heard testimony given here tonight with regards to what occurred prior to the death of Mary Minkle concerning the execution of her will. Excuse me. You have heard testimony given to you that the proponent of the will, her son Charles Minkle, had indeed developed and ingratiated himself to his mother to such an extent as to create a position of trust and confidence within his mother in his abilities and his love and care for his mother. You also found that Charles Minkle lived in the house, was the only other occupant of the house at the time in which Mary Minkle lived there with him after her husband died. You also found that he did many things for her. She had great trust in him. The things that he did for her, writing her checks, paying her bills, leasing the farm, taking her to the doctor, taking care of her every need, repairing the farmhouse, everything that could be done, including any minor repairs or even major repairs to the extent of replacing the roof on the farmhouse. This son did for his mother. He was in a great position of trust and confidence. And I relate to you that he violated that trust and confidence. He exerted such undue influence upon his mother as to take away that free will that she had in making her own last will and testament. She had no choice. He had brought her to the verge of tears. You heard testimony to that effect. That verge of tears took away her free will. She had no more free will. All she knew is that her poor son Charles needed to be taken care of. That her daughter, the doctor, had $200,000 a year in income and was well taken care of after she ran away to Colorado. He never had a chance. He never got the education that his sister did. His parents loved them equally. He had the same opportunities, but for some reason, poor Charlie couldn't take advantage of them or didn't take advantage of them. Just because Charlie didn't take advantage of the opportunities that were afforded him doesn't make him any more worthy than his sister, who happened to be bright enough or to recognize the opportunities and take advantage of them. That should not enter into or influence your decision in this case. One of the primary things that you should keep in mind is that Charles Minkle was in a position of trust and confidence with his mother. She depended on him almost 100% for her survival, if you will. He did everything for her. He was the only one there that she could rely on. There was no one else in that household. And will he profit from his undue influence? Your decision will decide. Will you let him profit from the manner in which he influenced his mother, to the total and complete exclusion of his only living relative, his sister? Are you going to allow this man to do that? Will you allow him to influence his mother to such an extent as to take away her free will? I don't think that you can do that. And I think that after the court properly instructs you with regards to what constitutes undue influence and what raises a presumption of undue influence, you will find definitely that he, number one, was in a position of trust and confidence, and number two, had the opportunity to influence his mother, and number three, he is now attempting to profit from it to the extent of some $2 million. Please, ladies and gentlemen, don't let him do that. Thank you.
When I have someone come to me and draft a will and exclude one of their children, as is the case here, I guess I go a little further than the consular did in this case, and that is I'll videotape a conference with that person for a couple of hours, and then there would never ever be the suggestion of what's happened here. This is the suggestion raised by the doctor, and only by the doctor, by the way. It's her suggestion. It's not proven. It's not even close to being proven. And I rely on the court's instructions. And I won't say any more about that because they haven't met their burden. We are free to choose the object of our bounty. That's our inherent right in this country. And our inherent right says that if we want to exclude a child, such as the doctor, who's well off financially, we can do so. Plain and simple, we can do that. We can do that, and nobody should really come into a courtroom such as this and challenge. I mean, they're challenging this lady's desire for her estate. And they're challenging without any evidence other than what the doctor could suggest to you. And I don't believe her testimony. I don't believe it one iota. And I guess I don't believe it when we talk about a $2 million offer, and I never heard anything about that during the course of the deposition. And I take depositions to find out what kind of testimony we're going to be faced with. Depositions are taken to try to get to the truth and maybe settle this case before we have to spend 2 days in front of a jury at a lot of cost and expense to both sides. Will he profit by caring and having cared for his mother? Will he profit by getting the farm? I hope so. I think he's entitled to profit. I think he's entitled to profit because he's the lad who stayed home with his mother and stayed with her whole life, other than for his obligation to his country and serving the Marine Corps in Korea, which I think is worthy. So, should he profit from all those years? Yeah, of course he should profit, just as the doctor has profited. She has profited by the education that she desired, by going through the University of Michigan, by having parents who paid a portion of her way, 25% she claims, 7 years of that. And she's profiting now and could profit a lot more. Apparently she likes the clinic style of practice and is satisfied with $70,000 a year. I would be too. That's a lot of money. That's a lot of money. That's a lot more than Charles has. Was he despondent? I guess he was despondent. I would have been despondent if I'd have been a Mueller Brass employee. Look what happened to the men that worked there for years and years. Look what happened to them. Look what's happening to them even yet to this very day. That's a travesty. That's a travesty, and that's the problem when you work for someone else. When you work for someone else, you're at their mercy. I'm very thankful that I work for me. I'm the only guy who can fire me. Do I get despondent? Of course I do. Of course we all get despondent. Life isn't all, I can't think of a better term. A bed of roses? It's not that. And if you think it is, then you haven't had much life. I know your ages, and I know you've had that life with some despondency and some problems. I don't believe the suicide claim whatsoever, and there's no evidence, good evidence, to justify that. And then let's finally look at the last will and testament of Mary Minkle. Her second paragraph of that will says, "I give, devise, and bequeath all property owned by me at the time of my death, real and personal, and wherever situated, to my son Charles Minkle, if he survives me." He has survived his mother. Had she forgot about her daughter? No, because in the next paragraph she says, "In the event my son Charles shall fail to survive me, I give the estate to my daughter Betty." So she didn't forget her object of her bounty. She knew her daughter was there. She just knew her daughter didn't need her help financially. She'd given all that help necessary. But I've said more than I should have said, and I've clearly run out of time. Listen to the instructions and the burden of proof on what's required to overturn the will of Mary Minkle. Okay? Because if you do what Mr. Nelson suggests, that's what you're doing. You're overturning her will. And there better be a lot of proof there, and I suggest to you that there isn't a lot of proof there. And if you have any doubt, if they failed to meet the burden, by the way, it's a preponderance of evidence. They have to carry the football from the end zone across the 50-yard line. That's what preponderance of evidence means. And I suggest to you they haven't done it. And you should affirm the will of Mary Minkle. Thank you.
Mr. Nelson.
Ladies and gentlemen, I will be brief. Council has asked you to uphold the will of Mary Minkle. I suggest to you that my client is not trying to break the will of Mary Minkle. She is here to disallow the will of Charles Minkle. Thank you.
Gentlemen, as a housekeeping matter, I believe that the proposed last will and testament has been admitted as an exhibit in this case. Is that correct?
It was previously, Your Honor, by stipulation.
Both councils
And
stipulated.
who has that in their possession?
I have the original, Judge.
You might leave that with the jury. That will be the only exhibit that they will take with them. You hands the bailiff, please. Sure. See if they get it. Jury room. Thank you. Members of the jury, the evidence and argument in this case have been completed, and now I will instruct you to the law that you are to follow. Faithful performance by you of your duties is vital to the administration of justice. The law you are to apply in this case is contained in these instructions that I'm about to give to you, and it is your duty to follow them. You must consider them as a whole and not pick out one or some instructions and disregard others. Following my instructions, you will go to the jury room and deliberate and decide your verdict. It is your duty to determine the facts from the evidence received in open court. You are to apply the law to the facts and in this way decide the case. Sympathy must not influence your decision, nor should your decision be influenced by prejudice regarding race, sex, religion, national origin, age, handicap, or any other factor irrelevant to the rights of these parties. The evidence you are to consider consists of testimony of the witnesses and the one exhibit. The admission of evidence in court is governed by rules of law. From time to time, it has been my duty as judge to rule on the admissibility of evidence. You must not concern yourselves with the reasons for these rulings, and you must not consider anything which was stricken. Arguments, statements, and remarks of attorneys are not evidence, as I've said before, and you should disregard anything said by an attorney which is not supported by evidence or by your own general knowledge and experience. I've not meant to indicate any opinion as to the facts by my rulings, conduct, or remarks during this trial, but if you think I have, you should disregard it because you are the sole judges of the facts in this case. In determining whether any fact has been proved, you shall consider all of the evidence bearing on that fact without regard to which party produced the evidence. You have a right to consider all the evidence in the light of your own general knowledge and experience in the affairs of life, and to take into account whether any particular evidence seems reasonable and probable. However, if you have personal knowledge of any particular fact in this case, such knowledge may not be used as evidence. You are the sole judges of the fact in this case and must determine which witnesses you will believe and what weight you will give to their testimony. In doing so, you may take into account each witness's ability and opportunity to observe his or her memory, his or her manner, while testifying, any interest, bias, or prejudice he or she may have, and the reasonableness of his or her testimony considered in the light of all the evidence of this case. Although you may consider the number of witnesses testifying on one side or the other when you weigh the evidence as to a particular fact, the number of witnesses alone should not persuade you if the testimony of a lesser number of witnesses is more convincing. In this case, the contestant, Betty Minkle, contends that the document offered as the last will and testament of her mother, Mary, should not be admitted to probate. The law does not require property to be willed to heirs or relatives. The law allows everyone who is not under undue influence in making a will free to leave her property as she chooses. The court and jury have no right to substitute their judgment for the judgment of the person making the will, or as to the wisdom or justice of the provisions of the will. Undue influence is influence which is so great that it overpowers the decedent's free will and prevents her from doing as she pleases with her property. To be undue, the influence exerted upon the decedent must be of such a degree that it overpowered the decedent's free choice and caused her to act against her own free will and to act in accordance with the will of the person who influenced her. The influence exerted may be by threats, persuasion, fraud, misrepresentation of a material fact, physical coercion, moral coercion. A will which results from undue influence is a will which the decedent would not otherwise have made. It disposes of the decedent's property in a manner different from the disposition the decedent would have made had she been free of such influence. The word undue must be emphasized because the decedent may be influenced in the disposition of her property by specific and direct influences without such influences becoming undue. This is true even though the will would not have been made but for such influence. It is not proper for a child to advise, persuade, argue, solicit, entreat, implore, to appeal to the decedent's hopes, fears, prejudices, sense of justice, sense of duty, sense of gratitude, sense of pity, to appeal to ties of friendship, affection, or kinship, provided the decedent's power to resist such influence is not overcome, and her capacity to finally act in accordance with her own free will is not overpowered. A will which results must be the free will and purpose of the decedent, and that not that of another person. Mere existence of the opportunity, motive, or even the ability to control the free will of the decedent is not sufficient to establish that the decedent's will is the result of undue influence. The contestant has the burden of proving that there was undue influence exerted on the decedent in the making of the will. A will is not valid if it was made as the result of fraud. Fraud exists if there was a misrepresentation of a material fact to the decedent, and the decedent relied on and was influenced by that misrepresentation in disposing of her property by will. The contestant has the burden of proving that there was fraud in the making of the will. Your verdict will be that the will is valid if you find all of the following. It was not the result of undue influence. It was not procured as the result of fraud. Your verdict will be that the will is not valid if you find one or more of the following. That it was a result of undue influence. It was procured as the result of fraud. You'll recall, this is the unfortunate part. You've sat patiently through and listened to this trial, and you will recall that at the outset of the case, I said at the close of the case we must excuse one juror so that there will only be 6 left in the box to decide the case.
Your Honor, we'd stipulate to 7.
Mr. Nelson, is that correct?
No, I'm only speaking on behalf of my client.
Yes, I understand.
Your Honor, I would also stipulate to 7. If I may, there is one other matter. We have not stipulated or requested specific jury instructions. And if it would be allowable at this time, I would like to approach the bench with a request for an additional jury instruction.
You may.
Thank you. The will contest presumption of undue influence is established. Fiduciary confidential relationship is established. I'd like to request that this instruction be jury at this time.
Mr. Nelson, this is not so fast. Come back, gentlemen. Are you asking for Part A or Part B?
Part B.
I thought you were a little quick to agree, Mr.
Part B is only required. I think it's only completely applicable in this case. Establishing other things. Request B.
Jury instruction proposed by Mr. Nelson is denied. As I was saying, usually at this time it's my unfortunate task to excuse one of the jurors so that only 6 decide the case, but by stipulation of the respective parties, we can allow 7 jurors to go in and decide the case. We always pick an extra juror in case someone becomes ill or in a lengthy trial, some unforeseen event occasions itself, so that we can continue with the case and not lose all of the work gone into it at that point. Now we're near the end of this. When you go into the jury room, your deliberations should be conducted in a business-like manner. You should first select the foreman. She or he should see to it that the discussion goes forward in a sensible and orderly fashion, and that each juror has the opportunity to discuss the issues fully and fairly. When at least 5 of you agree upon a verdict, it will be accepted as the verdict of the jury. In your deliberations, you should weigh the evidence with due regard and consideration for each other's opinions. You should listen to each other's arguments with open minds and make every reasonable effort to reach a verdict. Before deciding the case, give impartial consideration to the views of your fellow jurors. This means you should give respectful consideration to one another's views and talk over differences of opinion in the spirit of fairness and frankness. It is natural that differences of opinion will arise. When they do, each of you should not only express your opinion, but also the facts and reasons upon which you base it. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you are convinced that it is wrong. However, none of you should surrender your honest conviction as to the weight and effect of the evidence or lack of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. If you wish to communicate with the court while you are deliberating, please have your foreman write a note and deliver it to the bailiff. It is not proper to talk directly with a judge, attorneys, or court officers or other persons involved in the case, even if the discussion has nothing to do with the case. During your deliberations, you must not disclose the state of your deliberations to others outside the jury room. Therefore, unless you reach a verdict, do not disclose this information even in the courtroom. Will both counsel approach the bench? Has the court admitted any proper instruction? Are there any other objections to the instruction given aside from what you've already given, Mr. Wilson? Very good. Thank you, gentlemen. Bailiff, would you rise, please? You solemnly swear that you will maintain order among the jurors, remain confidential concerning any communications or deliberations between them, not allow any communications by anyone to them except by order of this court, and prevent the disclosure of any information you might otherwise have about this case, so help you God.
I do.
Bailiff, then if you will take the jurors into deliberations, please. Bailiff, we have a jury ballot prepared for this. Court is now in recess, pending the jury decision.
This plus this could equal this.
This could be you. I say could because a lot of kids don't make it this far. Instead, they end up here, or worse yet, they end up here permanently. Don't drink and drive. It not only could wreck your friendship, but it could also ruin your future.
Thank you, Bailiff. Ladies and gentlemen of the jury, have you reached, or have you selected a foreman?
Yes,
Who is the foreman?
I am.
Would you rise, please? And would you deliver the verdict to the bailiff, please? Bailiff, would you read the verdict?
We, the jury, find the document offered as the last will and testament of Mary Minkle shall be admitted to probate. It's signed by the foreperson and bailiff.
Thank you. Do counsel for either the proponent or the contestant desire the jury to be polled?
I have no desire to have the jury polled.
No, Your Honor.
Thank you. With that, then, this trial is concluded. Thank you.
What you've just seen was a session of the People's Law School. This is a joint effort of the St. Clair County Bar Association, the St. Clair County and Michigan Trial Lawyers Association, Legal Assistance, and St. Clair County Community College. Much of the preparation and planning for the People's Law School is done by attorney Ron Flanagan. We'd like to have you join us at the next session of the People's Law School. If you are interested, please contact the St. Clair County Community College Continuing Education Division. I'll see you at People's Law School.